Oh, sorry for that. So as I was saying, law decided in 100 years or more may no longer be suitable. Ideally, Parliament should reform the law, but Parliament is sometimes slow to do this. I'll give an example of a case that happened in 1991, a very interesting case. Actually, I was laughing when I was doing my research around this area. So in this case, a man was charged with raping his wife. So the point the court had to decide was whether by being married, a woman automatically consented to intercourse with her husband and could never say no. So the old law dated back in 1736, when it was said that by their mutual matrimonial consent, the wife had given up her consent or had given up herself in this kind to her husband, which she could not retract. It means where a wife was married by a husband, and this wife, under that law that existed in England in 1736, it was presumed that she had consented to having sexual intercourse with the wife. In other words, once married, a woman was always assumed to consent and could not go back on this. Even though the wife had already started divorce proceedings, the Parliament had not done anything to reform that particular law. When this matter was brought before the Court of Law, the House of Lords in this case, the judges pointed out a key principle that the status of women and the status of a married woman in our law have changed quite dramatically, and therefore a husband and wife were considered as one party. And therefore, where a woman has not consented to marry, to have sexual intercourse with the husband, then the man could be found guilty in the law. This is a good example of where a law that is crude is being reformed or is being revised, okay, by the judges. Okay, so as a result of this, it was decided that if a woman did not consent, then her husband could be guilty of rape. That is one instance which we can say the judges have applied, or the courts of law apply the law to inform a particular case in line with the current situation. So the House of Lords in this case, they stated that the common law is capable of evolving, meaning the laws can grow in light of changing societal, economic, and cultural developments. And this position clearly recognizes that judges could actually change the law if it is done through proper channels. So this then answers our question whether judges make or declare the law. In this instance, we see a position whereby judges make the law, or they inform what the law is, or they declare what the law is through interpretation. But we also learned that the role of a judge is not only to adjudicate on matters, but also to ensure that in whatever they are adjudicating for conforms with the societal need. A second instance where judges may either make or declare the law is the application of the doctrine of precedent, where there are certain particular cases, decisions are made, and these cases become grand norm principles that have to be applied by courts of law. Whether they are developing the common law or interpreting statutes in the main is the main mechanism whereby judges make law. However, occasionally, judges are called upon to give a ruling or to make decisions when faced with situation for which there seems to be no precedent or any other governing principle. In that instance, you need a judge or a court of law to interpret that particular provision of law. Using precedent, it means they use well-decided cases which have principles in them, and those principles inform what the law is. In certain circumstances, judges could be said to be formulating original precedent. Thus, it is the judge's role to use their own discretion, their own ability to think and to reason with the law when he thinks rules need to be applied, when he thinks rules need to be changed, or when he thinks rules need to be improved, or where he thinks that rules have to be abolished for the reason being these rules could either be against human rights or they could be repugnant to justice and morality. I'll give an example of what used to happen in the past, where women were not allowed to own property. Women were considered to be men's property. And therefore, where a matter was brought before the court, a woman was not supposed to bring a matter before the court of law. Because of this, people who were advocating for the rights for the rights of human beings thought it wise that women are human beings and they deserve to be treated in a dignified manner. As a result of that, it necessitated the changing of this law where Parliament declared it repugnant. Repugnant means it is against justice and morality, or it cannot be applied. Although the function of law is being one of systematic rules, there's a firm belief that where there are gaps in the system, then judges use their own discretion when applying the law. So the law gives judges the liberty to interpret the law in a way that grows the law and promotes or advocates for a change in the society. In this instance, we can conclude by saying, whereas the function of the courts or the function of the judges is to adjudicate on matters, indirectly they also have a responsibility in ensuring that the laws that they are making conform to societal need. The laws that they are making are laws that when brought before the people, those laws can actually be informing the day-to-day affairs of human beings. I also agree with, having read through these, there's a belief by Hart, one of the scholars, who believes that statutes and common law rules are often too vague, and most of the time they are unclear, and therefore it is often inevitable or in hard cases for a judge to create a new law. With that in mind, he therefore talks about the open texture of the law, which means that indeed areas of conduct where courts or officials strike a balance in the light of circumstance between competing interests which vary in weight from case to case. It therefore means that laws can be decided on a case-to-case basis. Judges have a role to make laws. However, in making those roles, one of the principles that they must follow, that principles control interpretation of rules. The principles that are already provided for by Parliament, for example, in our case, the interpretation statute, those principles control the interpretation of rules by the judges. And those rules that the judges use to make their decision derive their meaning from the principles that have been made by Parliament. It therefore means that through the rules of precedent, merely discovers and declare the existing law and never make new laws. In simple terms, this means, for example, in our Kenyan context, there are statutes that are used for interpretation. Interpretation statutes are used to interpret certain rules. And therefore, when a judge arrives at a decision, he does not arrive at a decision on a vacuum, but he arrives at a decision on principles that inform the rules which derive their meaning. So that a judge makes a decision, it means that a judge makes a decision not according to his own private judgment, but according to the known laws and customs of the land. This principle, for us, it should mean that judges do not make the law. They only declare what the law is. And in declaring what the law is, they use principles to declare what the law is, or they use principles to interpret rules that inform their decision. This is now an instance. In the first instance, we have looked at judges have a role. There are certain instances where judges make rules. But in this second instance, we are looking at a position whereby judges do not make rules. Judges do not make laws, but judges declare existence of law, or they affirm the existence of law by expounding on what a particular law already provides for or exists. And this, I would base my assumption on two reasons, on twofold reasons. One is that elected representatives who are responsible to the people should govern a community, and when judges make law, it will be an encroachment on legislative power. So that is one reason why we say judges do not make laws, but judges declare what the law is. And in declaring what the law is, they use principles. And those principles are used to define or to interpret the rules that inform their decision. And secondly, one would say that, for example, if a judge makes new law and applies it retroactively, in the case before him, that particular judge then, where parties have come before them, the losing party will be punished, not because he violated some duty he had, but rather a new duty created after the event. It means, again, whereas judges have a role to make the law, whereas judges have a role to interpret the law, judges also have a duty under the law to use the principles that have been provided by a particular jurisdiction, for example, in Kenyan context, to come up with their law. You will realize that in the just concluded, when the Court of Appeal made a ruling concerning the Building Bridges initiative. And if you look at how the High Court reasoned in terms of their decision, and when you come to how Court of Appeal reasoned in their decision, you will realize that somehow the dissenting judge, especially the dissenting judge, the one dissenting judge, had her own way of reasoning in terms of interpretation of this, of that particular, in terms of interpretation of how it was done at the High Court level. But in arriving at her decision, she was guided by certain principles. For example, when she was analyzing the basic structure doctrine, she agreed, but somehow she differed with what some of the judges were saying. And so again, a good example again is an instance where she actually said that the IEBC had a quorum, and that you do not need the whole bench, or you do not need the whole participant or the whole committee of the IEBC, I mean the whole commissioners, to come and ensure that the particulars of the signatures have been verified. I mean, it was her own way of reasoning in the law, but she was guided by principle. Furthermore, judges don't make law because the existing law provides all the resources for their decision. For example, a judge does not decide a case in a legal vacuum, as I said, but on the basis of existing rules. It's, however, worth noting that that even if the rules of statutory interpretation, if those rules are clear to all, the statement of it may often be made in the form of prediction of the court's decision. But the important thing to be noted again is that the basis for such prediction is the knowledge that the courts regard legal rules not a prediction, meaning the interpretation of the law to come up with their decision. In conclusion to my